Hi, welcome for our event today. We have three topics that we'll be covering in different segments, and the first is mobile home and apartment rental rights. I'm Michelle Reinen from the Department of Agriculture, Trade, and Consumer Protection. First thing today is I want to cover exactly what we do within the Bureau of Consumer Protection. You're going to hear from a couple of us today up here on different topics, but we're here as the state agency to ensure fair business practices for buyers and sellers. So we want to make sure that there's a balanced marketplace, and we work to make sure that we prohibit fraud, deception, and unfair practices. So really we're out there making sure that advertisement is truthful and honest, and people aren't using unfair practices to deceive consumers when making purchases. We have authority under state statutes to do this work, as well as through administrative codes, and we also have some administrative authority through special orders. So that's just kind of some of the logistic aspects about our agency, and then how we serve Wisconsin consumers and businesses. We have the consumer hotline. So that's there for both consumers and businesses to ask questions, have information sent out to them, kind of guide you on the website if you want to access it yourself, but you can ask questions and we can indicate whether or not it may be a good idea for you to file a complaint. The hotline can also check out a business for you before you engage in a contract or some kind of transaction with them. We also have an outreach and education program, and so you're seeing that here today, where we go out and inform consumers and businesses about the laws and the rights. And finally, we have mediation, investigation, and enforcement. So that's where a number of our staff look at those consumer complaints, mediate issues with those businesses that consumers have had transactions with. And then if they see some practice that's in question or a pattern of conduct, they'll request that an investigation be opened, and then we can do that investigation, if need be, refer that matter for enforcement with either district attorneys or the Department of Justice. Now, getting right into what we're here today for, mobile home and apartment rental rights. Really, we kind of lump this into what we call landlord-tenant. You can see this is our number 2 complaint category, with more than 1,600 complaints received from consumers last year, where we received over 11,000 complaints. All of these were received in writing. That's what we consider a complaint. It's not when someone just calls our hotline and asks a question. These are individuals who've had issues or problems with their rental situation and go to the measures of documenting that, writing it down, and filing that complaint, and ask for the agency's assistance in trying to resolve the matter. So number 2, and traditionally, over time now, at least 10 years, it's number 2 in that spot as well. So it's pretty consistent in where it lands as far as a complaint goes. So I want to just point out for reference, and we have information on our website. We have handouts here today for individuals attending in person. But for point of reference, the rules and statutes that govern this area of rental, if you're in a manufactured home or mobile home area and you're renting, or whether you own your home and rent the property, that's Wisconsin Administrative Code ATCP 125. That is specific to those properties. But in addition to that regulation that talks about the property and the site, we also have a landlord-tenant regulation administrative code, ATCP 134. So if you are in a traditional apartment, whether it be renting a home or a high-rise apartment or maybe a duplex situation, the landlord-tenant 134 is going to be what could apply to you. But if you are in that mobile home park, you could have the 125 and the 134 administrative codes apply to your situation. So you it's governing a couple different areas of that practice. And then in addition, there's Wisconsin State Statute 704. This gets into those rental agreements and regulations as well. This is, again, a state statute, so the legislature has gotten together and passed that law. And we don't have specific authority or jurisdiction. So we aren't the ones that can bring an action under that statute, but we do advise, inform, and we do have points of reference from our administrative rules over there. So all very complex, but it kind of sets the tone for what we're going to talk about as your rights today in these different areas of regulation. So first, because this is kind of a dual conversation that we're having today, is the mobile home rental agreements. So if you're in a mobile home, again, or in a mobile home park, there's these specific regulations that govern that transaction. So some things you'll see will really overlap in their nature, but all agreements need to be in writing. If you're in a mobile home park, you need to have your agreement in writing, and you need to get a copy of that executed agreement. So once you sign it and the operator of the mobile home or manufactured community signs it, you need to get that executed copy. And then there's all sorts of things in the regulation that the agreement should include, and they're listed up here, and it's the amount of rent and all the property, services, and facilities that are included as part of your agreement. You know, what you have access to, what you're renting, what you'll receive in exchange for that rent money. And then your agreement also needs to list the amount of security deposit, if there's installation charges for moving your home in, and other charges not included in the rent. Those could be things like utility services that are provided by the operator's facilities. So because you're renting this home, but you need to hook up to utilities, the operator probably operates those utilities and then passes through that charge. All that information needs to be part of your agreement. You know, often when you're borrowing someone's space, whether it be in the apartment or this mobile home facility, there's going to be rules and regulations. Maybe they're about quiet hours, maybe they're about pets, visitors, decorations, how you might do your landscaping. Who knows what's going to be covered, but those rules and regulations also need to be part of your written rental agreement. So you understand what rules you need to follow, and you know what the operator's expectations are as part of that. This document also, it's a contract, so it needs to include the property information, the size and location of what it is you are renting to put your mobile home, the amount of the monthly municipal permit fee, because that often goes along and gets passed forward to you, so you get to know what that is in writing. The amount and due dates of fees assessed for waste hauling, recycling, and other similar services that'll be provided, because we all produce that garbage and have it hauled away, and so that's going to be something that's passed forward. And then again, we're repeating, you need to get a copy of those rules and regulations. It's part of your agreement, and so you should be receiving a copy of that as you receive that executed agreement. Some other things, again, as I mentioned, mobile home is very detailed, and so I'm going through it pretty quickly because these segments today are pretty short, but the agreement shall be for a term of no less than 1 year. The only way it can be shorter is if you request something in writing that's less, and the operator agrees to it. But otherwise, with mobile home parks, it's very specific that it should be no less than 1 year, because there's this big thing you've just moved in and parked, and it's pretty hard to move back out. And the person who may be contacted concerning maintenance of the facilities and other services that are provided, you need to know who you reach out to, and that should be part of that agreement. Because it may not be the operator itself. They may have hired a maintenance person or some other point of contact, and so you need to know who that is. And then rent and other charges may not be increased during the term of the agreement. You've signed this rental agreement, and it tells you how much you have to pay for the length of the agreement. Now there's going to be one exception to this, and we'll get to that in just a minute, as in right now. So the agreement can be for a period of 3 years or greater. But all of the following conditions have to be met. And this is because, again, you've moved this large piece of property in, and you may be paying it off or have an investment with the bank. And so you need some foundation. You need some stability about how long you're going to be there. So you can have this longer agreement if the amount of rent due each rental paying period, so let's just say you pay by the month, may be expressed as a formula that can include a base dollar amount and a future adjustment factor tied to CPI. Very complex. But it means that you know how rent will increase over that length of time of 3 years or longer. So like the 1-year agreement, you have a locked rate that you pay on that regular basis and the rent can't increase. But over this longer course of time, you can imagine that prices go up, but you need to be able to project what that's going to look like. And so you can do that. But the only way you get to enter into one of these longer term agreements is that you have to be offered the option of something less than 3 years, an agreement that's less than 3 years. The agreement specifies the initial amount of rent due, so that first rental payment period, and the tenant's provided you, the tenant, the actual dollar amount of rent due in future rent paying periods, so you can project, you get numbers, not just formulas and information. And then if that actual dollar amount of rent due changes under the formula, you're provided notice at least 60 days before that new dollar amount is due. So when that formula kicks in, you get notice about that increase so you know, and pay the right amount, because there's consequences if you don't pay that proper amount. All right, so that was the complex, very detailed information that's really important to know regarding mobile home parks. But now just general landlord-tenant regulations. So now you live in that apartment, that duplex. Maybe you've rented a home from somebody. So you get an agreement, and there's times when you are entitled to a receipt. But most times you don't get a receipt. So written agreements must be provided to a tenant if your agreement is written. You can have a verbal agreement with a landlord. There's nothing preventing that from happening. But when it's in writing, you as the tenant have to receive a copy. So that agreement needs to identify, again, the landlord, who you're renting from, and those authorized agents, because maybe they have a management company that handles everything for them. And again, you need to know who you're dealing with, the person you're going to pay the rent to. Who do you drop that off to? Maybe it's the person at the front desk. Maybe it's somebody at the building and no big deal. But who do you call when you need to maintain the premises? Who's managing the toilet that's overflowing? You know, who do you call for maintenance? That window that won't open on a hot, steamy day type situation. You need to know who to call. And then when are receipts required? Again, we make payments maybe on a monthly basis. You might pay earnest money, the money up front with your application when you're being considered. Your security deposit, you know, that secures you. You get that back at the end, hopefully. But then there's that rent. And again, maybe that's monthly basis. If you pay in cash, you are entitled to a receipt. If you pay by check, you're not entitled to it. You can request a receipt. If you're paying by credit card, no receipt. You know, the landlord doesn't have to. You can still ask, but there's no requirement that that be provided. So again, making sure you understand, if you're paying cash, you want proof, and so they have to provide you that receipt. Some landlords won't accept cash. You know, maybe it's for that reason, and a check is only if you ask for it. So other things, you know, we went over the length of term for mobile home rentals and that kind of thing in the park where you're renting that property. But as it relates to that apartment that you're in, you can get a 1-year lease. You can get that in writing if the landlord offers that. But there's also monthly agreements in this case. Or maybe there's a 6-month lease or 3 months. There's terms that you can have. So if you lock into a 1-year lease, what happens is, again, that's a written contract you've likely had. So you can get that in writing. But the landlord then can't raise the rent because you've agreed what the rent is for this length of time. You've locked it in, type situation. Now, if the landlord is not going to renew your lease, he needs to give you 60 days notice. So you can plan ahead. It's not, it might not be for any reason. They just aren't going to renew it. We're done. Let's end our relationship. It was good while it lasted, but let's be done. Maybe we don't see eye to eye on mowing the lawn. Let's just let things be. 60 days notice. So and can plan, look for that next place, hire that rental moving company or that truck. If no notice is given, then it likely turns into a month-to-month agreement. I will say it cannot automatically renew for another year. It doesn't just, no notice, no one says anything about renewal or anything. You don't get just locked in for another year. That can't happen under the regulations. So again, month to month, what happens here is you don't have that security of a year. You don't have that security of the next month, really. You've both agreed, we'll see how it goes on a month-to-month basis. And so either one of you, the landlord or the tenant, can say, I'm gonna 28 days notice, I'm done. We're gonna end the relationship again. But that's all that's required. The landlord's only required to give you 28 days notice, just as though you are only required to give them 28 days notice. Less planning time there, but less commitment as far as rents do if you need to leave on shorter notice. That 28 days. But it also means, when you're not locked in for a year, that the landlord can raise the rent at 28 days notice too. Things can change, rules can change. It's a month-to-month agreement, and things can change on a month-to-month basis. Any questions about that? That was just 4 slides with a whole lot of information. Yeah, go ahead.
So after a year at the place I'm staying, it'll automatically go to month, or I have to negotiate another year?
It could. That place where you live may not do month to month. So they may give you the 60. So the question was, after the year, does it automatically go to a month to month, or do you have to negotiate another term? So the landlord needs to provide you notice 60 days in advance to say, we're not renewing. Or he or she will say 60 days, here's your next lease. It includes a fee increase, maybe a rental increase, or maybe it'll include a rule change. We're no longer offering a pool, whatever it is. But the landlord also, and then you'd have 60 days to say, yeah, I'm going to sign the lease, because you need to give notice, I'm not going to sign this, or you enter into it. So they'll probably, in advance of 60 days, say, here's your new lease, or if you don't sign it, here's your notice, because we're ending it. They don't have to offer you a month-to-month. A landlord doesn't have to enter into a month-to-month agreement. If they offer such a thing, that's the regulations behind it. But certain complexes, they may want only people who are locked in and committed for periods of time. That might be their business operation.
Bottom line, if at the end of my first year there, they say, they give me a 60-day notice, I'm out in 60 days.
Bottom line, if they give you a 60-day notice at the end of or 60 days before the end of your current agreement, and they say, we're done, then you're done. You can go and say, can we work something out here? You could also go, I had a situation years ago when I rented, I needed 2 more months for the next place to be ready. And we agreed, I wasn't renewing for another year, but they were willing to extend my current agreement for 2 months in writing. But they knew when I was leaving. We planned this really 4 months in advance because it was 60 days before the end of my term. I needed 2 extra months. We put it in writing that, my agreement extended for that period of time. That shifted them to a better month for rentals, and I could get my other property. But so that sometimes is something you can do. Always, follow that in writing. But you can always have a conversation. And one of the very last slides here today is communication. Just communicate and have the conversations and follow them up in writing.
Thank you.
Yeah.
I had a question.
Please.
Now, if you're a month-to-month rent and you decide to move out, do you need to give the landlord 60 days notice or 1 month?
So if you are month-to-month rent, do you need to give the landlord 60 days notice or just 28? The law indicates that you need to give 28 days notice, and the landlord needs to give you at least 28 days notice. The landlord may give you more, 60 days notice, but at least 28 days notice, and the tenant needs to give at least 28 days notice. You could give more as a courtesy to let them know, but the law indicates and says at least 28 days notice.
But if your contract says 60?
If you've signed an agreement that indicates something that's longer, you have a contract, you could give, but if a circumstance arises for you where you aren't able to give that, the law indicates at least 28 days.
And then you would not be forced to pay for the extra?
Well, that is something where they may try to charge you, and you'd contact Consumer Protection about that matter. Because the law indicates versus what your contract indicates. So the law says that you have to give at least 28 days, and if you've given that, there's an argument to be made you followed the law. So, but if you've agreed to something longer, give that, but if life prevents you from doing that, give that 28 days. Does that make sense? Okay, go ahead.
What if the whole facility is closing? Are the rules the same?
If the whole facility is closing, about the landlord giving you notice? I mean, that's what you're asking? Those are situations that we really have to deal with them case by case, because it probably depends on why the facility is closing. Is it a health and safety issue? Are they bankrupt and can't operate? I mean, those are very different circumstances than daily operations, and so we would have to look at them individually. If it's because they're selling the property, and then the contract should be honored. And so the person who's buying should understand how long those agreements still exist for.
Communication, but does that communication include calling you guys at that hotline number and say, hey, help me out?
Yeah, absolutely, absolutely. So we have a few minutes left. I'll jump through these disclosures. So when you're picking your place of where you want to rent, landlords need to disclose if there are code or violations or habitability issues, if they know of code violations that haven't been corrected yet. So maybe something's funny with the toilet or something, or maybe something's funny with a window, and your local building code inspector has put a code violation on. They need to disclose that to you so you can make an informed decision. If the heating facilities can't function at a temperature and they know that, they need to disclose it. You can still rent, but maybe it can't get to 67 degrees. You should know that. Maybe it only locks up, 63 right now, and he's fixing it in 2 months. Utility charges. If you aren't going to be hooked up with the utility company directly yourself, and the landlord's charging you utilities because it's a metered property and it's shared, they need to tell you how those are going to be shared. I'm jumping to promises to repair because of what I just said about the heating. Maybe it can only get to 63, but they're going to fix it in a month or two. The furnace guys come in, they're on the wait list. Well, that promise to repair, at the time you're considering the property, they say, yeah, the furnace guy's coming in 2 months, we're going to get it fixed before winter. Promises to repair should be in writing. So up front, when they're renting you that property, we need to get those in writing. It should have that specific completion date, and they must be completed on time under the law. So if they're walking you through that property and they're telling you things about, yeah, no, I'm going to fix the latch on that window, get all that in writing, and that's what should be done when they're making those promises, and it should include that information. I'm not going to go into great detail here, but what I want you to know about this is that there are certain provisions that are prohibited in rental agreements. And we'll get you these handouts, and the landlord-tenant guide has them all written there because it's something to study, but just as a general overview, things that are prohibited. Increase in rent or decrease in services, refusing to renew or bring an action because a tenant contacted law enforcement or health or safety services. They can't, landlords, retaliate. Basically, they can't retaliate by increasing your rent because you called the building inspector about that window latch or whatever. So there are provisions in that agreement. You know, if you saw an agreement that said, I promise I'll never call anybody. Well, no, they don't get to have those kinds of things in the agreement. And there's all sorts of other things in here, like accelerating of rent for failing to mitigate damages. And what that means is if you had to leave early and give notice, the landlord has an obligation to try and rent that property, mitigate what you're responsible for. And they can't just say, no, I'm not going to do that in the agreement. There's also prohibited practices, things a landlord just can't do when trying to rent property. They can't just come in and enter for no reason whatsoever. A landlord can come in and inspect. That's their investment. That's their property. And they have a right to inspect and check it out. They need to give you 12 hours notice and tell it for a reasonable time and tell you when they're coming. Now there's an exception to that. If they see water leaking out or smoke coming from, they can, you know, it's an emergency situation. They can get in there and check out what's going on. But again, they can't just unauthorized entry. I wonder what's happening over there today. I'm just going to go enter, knock, knock in. Nope, 12 hours notice to do that inspection. And there's other things, again, that are in our landlord-tenant guide on those specific prohibitions. But one of the, I kind of am ending here except for our complaint process on the regulations, and that's this earnest money deposit and security deposit. Because these can be big numbers. You know, you pay your rent on a regular basis, likely monthly. But earnest money, again, is that money you put down usually with an application to say, I'm serious about this. So there's regulations about collecting that, returning it, and withholding it. So if you fill out the application and give your money, now you're on the hook for this. If the landlord comes back and say, approved, it's yours. If you back out, they can withhold that money, but if they rent it and there's no loss, there's mitigation. However, if you, before you're approved, say, change my mind, then stuff needs to be returned. If you agree, they say you're approved, yeah, I want it because I was serious, I put money down, you sign your agreement, that earnest money can convert to some of your security deposit. It can move forward now. So let's just say your application fee, your earnest money was 30 bucks. That's not big money, but we'll just use that number today. That can now move towards your security deposit of $300. So now you only need to, when you sign the rental agreement, and they want a $300 security deposit, you'd only owe them additional $270. Your agreement should say $300 because the $30 from earnest money gets added to the $270, and you're really giving them a security deposit to $300. So as it relates to security deposit, this is money they're keeping, you know, until you move out, in case damages happen, in case you damage the property. So you want to document what the property looks like when you move in. That's the check-in procedure. Within those 7 days, those first 7 days, fill out a sheet of paper that says there's a hole in the wall, the carpet is ripped, and that window latch is broken. You know, just put everything down in writing, keep a copy, give a copy. But that's the condition of the property when you move in. And that way you have documentation when you move out So the landlord can't charge you for the rip in the carpet, the hole in the wall, and the latch on the window that's broken. And if you hadn't done that when you first moved in, document it now. At least for argument's sake. You know, if you moved in a month ago or 2 months ago, at least document now what the condition is, and so that way if something happens later. Security deposit returns, that should be returned to you after you move out. 21 days after your agreement ends, 21 days after you move out, if you move out after your agreement ended. So that's when that should be returned to you. Or if you move out early and someone else moves in, they're able to get someone else in during your term, 21 days after that's been re-rented. Withholding, this is if they're going to hold any money back. Let's just say that ripping the carpet is from you, and they're going to hold some money over for that. Then they need to give you a statement saying that they're withholding because of a rip in the carpet and how much they're holding back for you for that rip in the carpet. So it's why and how much.
A written notice.
That should be provided in writing to you. It's a statement. Yep, that should be provided in writing. All right, a landlord can end things early. It's called termination of tenancy. If you're not following the rules and they've given you notice of that, or you're not paying your rent, the law, State Statute 704, does allow for these agreements to be ended early with notice. You get written notice that your agreement is ending either 5 days or 14 days, and you know the tenant guide goes into specifics as to which one gets served when, but you can get notice to say you have to be out in 5 days or 14 days because of you're not following something. You're not paying that rent, or you're not following that rule, and you've been given that notice about that. If you don't move out when the termination notice indicates you should, then they can start the eviction process, and that's through the courts. And then if the eviction's awarded, it can involve the sheriff and stuff. But prior to filing a complaint and all through the process, communicate. Read your lease before you move in. Review your lease now that you're renting there so you know, and document. Whatever communication you have, document, put it in writing, and as well get things in writing back and forth, because it really clarifies the he said, she said situations. But if you have communicated and things aren't going well, file a complaint with Consumer Protection. We'll get that complaint, we'll analyze and mediate it, get involved with the landlord, do written documents back and forth. We'll see if there are what we believe to be violations of the law, and we'll try and help out. We're not the court, we can't make the landlord do something, but often it can help a situation a long way. And so here's where you can file a complaint online, or again, you can just call our hotline and they'll mail you a form. But include your lease and any documents, rules and regulations that you have, receipts from paying your rent. We don't want your confidential and personal information, so if you can, mark that out. We don't need your social security number or your bank number. Just the receipts are fine, or that information. But contact Consumer Protection. We need that in writing. And then these are a list of publications that can help. Again, we have the Manufactured Home Communities Fact Sheet, the Landlord Tenant Guide, Tenants' Rights and Responsibilities, and copies of our laws, all on our website, or we can mail them out to you if you call the hotline as well. And I have them here today if you're here in person. Otherwise, if you're watching online, just go to our website and you can get that information. And it covers in great detail what I covered here today. And so you can take it at your own pace. But in our last couple of minutes, any other questions? And I'll be sticking around too between topics. Go ahead.
The recent PFAS water contamination in Wausau, has that been addressed as far as the water supply coming from the city?
I'm aware that there is a situation that the city is dealing with in providing filtered pitchers and things, but I'm not sure in what context you're asking your question about PFAS and water with rentals. Are you asked?
Are they required to make sure that the water is safe?
The landlords with the property? As I understand, the city has a program for individuals to participate in until I think the city is taking care of the problem. I don't know that the individual landlords have that. So I think that's a good question to ask your city officials about what's happening as it relates to rental property or even your building inspection would be a place to address that question about the PFAS and water here.
Thank you.
Yeah. Anything else? All right, like I said, I'll be sticking around if you have individual questions, but thank you for attending today. And contact Consumer Protection again if you encounter a question later or a situation that you're engaged in with your landlord. So thank you very much.